that. Can everybody see that? Right, smashing. So, hi, I'm Ruth Cummins, and I'm the archivist for the Calderdale office of the West Yorkshire Archive Service. And in this session, we're going to have a little look at the complicated world of copyright and what that means for researching with archives, publishing archives, and hopefully you'll get some useful content out of the session. It's going to be a whistle-stop tour of quite a complicated subject, but should include some interesting things. So as we're going along, if you have any questions during the session, just pop them into the chat, and then hopefully I've planned a bit of time at the end of the session for questions. So I'm going to start the session by saying I'm not a lawyer. Nothing I say today constitutes legal advice. If you need legal advice regarding copyright, please find a lawyer who I'm sure will be infinitely more knowledgeable than myself, but I thought I'd get that warning out of the way to begin with. So in archives, we deal with a lot of legislation that controls the records that we collect, hold, and make accessible to the public. From the Public Records Act 1958 to the Public Sector Reuse of Information Regulations 2015, the Local Government Records Act 1962, the Freedom of Information Act 2000, and the Data Protection Act 2018. We operate in a framework of overlapping and sometimes contradictory legislation that dictates what we should or should not do or cannot do with the records in our care. But there's one piece of legislation that causes more frustration and confusion and sometimes just outright fear in the world of archives, even more than data protection. And it's the Copyright Designs and Patents Act 1988. So copyright is something that most of us find very complicated. And the most frequent answer to questions about copyright issues is it depends, because it always does. It depends on what type of document we're talking about. It depends on how old the document is. It depends on whether we know who created the document. And it depends on what you want to do with the document. So what is copyright? So copyright is what is known as an intellectual property right. Other examples of intellectual property rights would be patents and design rights. In the United Kingdom, a piece of legislation that sets out the law regarding copyright is the Copyright Designs and Patents Act 1988. So this law sets out what works qualify for copyright protection, the definition of copyright, the duration of copyright, as well as what counts as copyright infringement. And there's a really long history of protecting copyright in this country, dating all the way back to 1710, with the Statute of Anne, because in this line of work, you're never too far away from an Anne, I've found. So this was the first piece of legislation that set out a term for the duration of copyright. This was a rather short 14 years, and it only related to published works. There were then a further 16 acts of Parliament related to copyright between 1734 and 1956, before the most recent one, which is currently in force, the Act of 1988. So this slide here shows what types of works are eligible for copyright protection. A common misconception surrounding copyright is that it needs to be registered in some way, but copyright is automatic once a work which is eligible for copyright protection is created. It is in copyright. If you take a photograph of the beach on a family holiday, the instant you have taken that photograph, it is in copyright. You don't need to register the work anywhere or put a copyright mark on it or post yourself a copy. Copyright is automatic on creation of a relevant work, and it exists in both published and unpublished works. So here you can see listed are some of the types of works: artistic works, musical works, film, broadcast, literary works, sound recordings, and dramatic works. A lot of these have very broad definitions. For example, artistic works include photographs, maps, and plans, and literary works can include emails and tweets, or X's. I'm not sure what we're supposed to call them anymore. A literary work as well. It doesn't need to be good and poetically beautiful, this wonderful poem that makes you cry with how amazing it is. It just needs to be original and given some sort of tangible form. It can't be in your head. Artistic works, it's the same. They just need to meet the definition of artistic works, regardless of artistic quality or craftsmanship. I could draw a stick figure of Anne Lister striding purposefully around Halifax about her business. It wouldn't be good, but it would be an artistic work. I was quite tempted to draw that and add it to the slides, but I've spared you all that. So then we'll move on to a couple of the sort of key terms in copyright that are used frequently and that I will mention obviously throughout this session. When discussing works in copyright, we'll talk a lot about the author and who owns copyright. That's very important. And copyright is usually owned by the creator of the work, and they are presumed to be the owner of the copyright in a work. However, this is not always the case. There are some circumstances when this does not apply, particularly for works sort of created in the course of employment, when the employer may be the owner of copyright, or when the creator of the work, for example, works for the government and is an officer of the Crown, in which case the Crown owns the copyright, and this is commonly referred to as Crown copyright. There may also be more than one copyright in a single item. So music's quite a good example of this. If you take a recording of a song, separate copyrights will exist in the recording. So there'll be the recording itself, then there'll be the sheet music, there'll be the lyrics. So where more than one person has rights in a work under copyright law, that work is one of sort of joint ownership. So it may be that there's multiple authors in a work. You can also assign your copyright to another person. So if the owner of the work has assigned the copyright to someone else, this second person is the one who would then be the owner of the copyright in that work. This slide also shows you and sets out sort of definitions for duration. It's important when we're talking about copyright to think, well, how long does copyright last? Again, infringement is when there's an activity or an individual or organisation sort of carries out a restricted act. Orphan works licenses is something that we will sort of talk about later on in the session, and what orphan works are as well. And then there's quite a nice definition of what intellectual property rights are as well. So I'm going to take a drink because otherwise I will get very, very thirsty. So I apologise for my sip of tea. So how long does copyright last? Well, this isn't always an easy question to answer because it very much depends on the work itself. Many people believe that copyright lasts for the life of the author plus 70 years. However, this is only true for certain types of works. For other types of work, copyright can last many years beyond the life of the author, plus 70 years. The duration of copyright is dependent on a number of factors, including the type of work, if the work has been published, the date of creation, and whether the creator is known or unknown. So on this slide here, you can see some basic sort of rules for duration of copyright in some different works. Remember when we're sort of saying lifetime should be assumed to be 100 years. That's what we assume lifetime to be when we're talking about data protection. So if you have no evidence of when somebody may have died, assume they lived 100 years, and you can sort of do the maths and work out, well, would they have been dead for sort of 70 years? But most of the duration of copyright in the UK is very long. Some say too long, especially for works that were not created sort of initially with any sort of commercial exploitation in mind, like shopping lists or doodles, which will also be in copyright. If you've ever made a shopping list or doodled something, it is in copyright. However, the duration rules that are on this table here in this slide relate to works that are considered published. already. And what we look after in archives, most of it is not published material, it is unpublished. So of course, the true picture is more complicated, as it always seems to be. So some of you may have come across this flowchart before on the National Archives website. It's the National Archives of the UK, I should specify. It describes the duration of a number of different types of work, which can be dependent on their date of creation, state of publication, what we know about who created them. And there is, so this is specifically for non-Crown copyright material. There is a different flowchart for works which are considered to be Crown copyright as well. And I think the lovely Summit team are going to share the links to these very useful flowcharts in the chat. Whenever you have a document and you're thinking, is this in copyright? This flowchart is so useful. I can't tell you how often this gets used. Coincidentally, when speaking about Crown copyright, this flowchart itself, as it was created by a government department, the National Archives, is in Crown copyright. So I had to get permission, or ensure I had permission to use it. So I've been able to use this under the terms of the Open Government Licence, which is a set of terms and conditions that allows for the reuse of a wide range of public sector information. So if you're ever interested in that and you're potentially looking at some Crown copyright material, the National Archives website includes lots of great guidance on Crown copyright and the Open Government Licence. Now, when looking at this non-Crown copyright flowchart, one date that you might notice appears quite a lot is the 31st of December 2039. So let's talk about the 2039 rule, which is a date I probably find myself saying every single day. It relates to unpublished works and extends copyright in unpublished works to the 31st of December 2039, regardless of when they were created or when the author died. It's 2039. It's an added complication for archive services, especially when dealing with older unpublished material, as it leaves us with a considerable number of orphan works to manage. So these are works that are still in copyright, where the rights holder is unknown or cannot be found. So if you think about a World War I diary from a soldier at the front, or a letter from a schoolboy back to his mum in 1786, or a private charter that's over 700 years old. These are all probably in copyright to someone unknown until 2039. So if you imagine that somebody discovers a previously unknown manuscript by William Shakespeare. Shakespeare died in 1616, which is a time before the existence of copyright law as we know it. When Shakespeare was writing, he wasn't thinking about copyright. It wasn't really a thing. Yet, because of the 2039 rule, and that it would apply in this case as it would be an unpublished manuscript, this newly discovered manuscript would remain in copyright, and anybody wanting to publish or perform the play would have to seek permission from the copyright owners, and seek permission would involve tracking the chain of title across a period of 400 years and numerous generations, and wills and bequests, which is obviously time consuming and incredibly costly. If we're talking about new Shakespeare, the effort's probably going to be worth it, and somebody would probably do that. But for the unpublished records typically held in archive institutions, who would want to take on such a task, and who has the time and who has the resources? So this can sort of severely limit the way in which archive services can encourage use and reuse of the items in our care. It impacts publications, exhibitions, digitisation projects in a major way. So I'd mentioned sort of orphan works a little bit in the last next slide. So these orphan works which remain in copyright under law to someone, but that someone is unknown and most likely do not even know that they are a rights holder. Orphan works are almost inevitable given the length of duration of copyright, particularly for all those documents from potentially centuries ago the 2039 rule applies to. Combined with sort of the lack of need to register copyright and tracking the transfer of, it through inheritance potentially, unpublished orphan works in copyright until 2039 are going to be, a significant amount of the items within archive collections. And clearing sort of the rights, getting permission from the rights holders, conducting a diligent search for a rights holder, it can take a lot of time and money. For some types of work, it might be easier to trace rights holders than it would be for others. Commercial creations, where the work was created to make money from someone's creativity, like a professional photographer, a writer, or a designer, it's more likely that somebody somewhere is protecting that commercial asset. If you think about the author J.R.R. Tolkien, his estate holds and manages the copyright for his literary works. The search for a rights holder would very quickly lead you to the Tolkien estate. Sort of 2 seconds and Google, bam, you found your rights holder. But it's never really that easy. For those kind of works, the rights holders tend to be far easier to trace. But for things like diaries and letters and family photographs, which is usually the type of sort of work that archives are dealing with, it is much harder to trace those things. We do have in the UK an orphan works licensing scheme, which I will, give us slightly bit more information about later, but it's complicated to navigate and there are costs involved to make sure that if a rights holder comes forward, it defrays the risks of a claim. They also provide really good guidance on conducting a diligent search for a rights holder as part of this scheme, and the steps you sort of need to be able to take to demonstrate that you've searched for a rights holder can be quite exhaustive. So the general approach of most archives is, if in doubt and the risk is too high, once you've weighed up, don't use in copyright orphan works for displays, exhibitions, publications, online access through digitisation. So we're going to sort of move on a little bit to copyright infringement. So this slide here shows a few examples of acts of copyright infringement, as well as definitions of primary and secondary infringement. So copying can include photographing, photocopying, tracing, and manual transcription. And showing material, for example, exhibiting an in copyright document in a case when it's not an artistic work and it's still in copyright has been historically a little bit problematic for cultural heritage institutions like museums. Back in 2014, the government had a consultation on copyright, and the Imperial War Museum in the UK made a point of this by not displaying any items from World War I in their cases. Instead, they displayed a note in the case which basically said, copyright says no, we're not allowed to do this, to sort of make a point that perhaps the law during this consultation could be tweaked, could be changed. To deal with this issue, the government didn't change the 2039 rule or rules around orphan works. Instead, the Intellectual Property Office, who's the regulator, issued an advisory notice in 2015 that, in its view, the unauthorised public exhibition of copyright, literary, dramatic, and musical works did not infringe copyright or constitute publication. So they relied on a statutory interpretation of the law rather than actually changing the law to make it less restrictive. But it does mean we can now see things from World War I in the Imperial War Museum, which, can only be a good thing. So yeah, secondary infringement is quite important to consider. You might not necessarily be publishing the material yourself, but if you sort of knowingly allow someone to copy material in that's in copyright without the permission of the rights holder, or using an exception that allows copying, and I will get onto the exceptions in a second, then you could also be infringing copyright. Same with publication. So if we supply a copy using one of the exceptions for non-commercial research and private study, knowing that a user is going to publish that on a website, we could potentially be infringing and sort of liable as the archive service. And at this point, it would need to be a publication request and permissions would need to be looked into. So we use copyright declaration forms so that we have a record that everyone has been informed of what the law says and how we are able to provide copies. But if we are aware that the researcher is going to say, go home and email a copy to their cousin in Australia, we cannot legally supply them with a copy, and we would at this point have to explain why. So I guess one of the questions you might be asking is, if copying a work is an infringement without permission of the rights holder, and archives are absolutely chock full of in copyright works, how do we provide copies to people who visit our search rooms for research purposes? Well, we make use of certain exceptions within the law which allow us to provide copies in particular circumstances. You can see some of the exceptions here on this slide. A lot of times when discussing copyright, the term or the concept of fair dealing is mentioned a lot. I will say that fair dealing does not usually apply to publication, apart from the inclusion of quotations for sort of criticism and review. And there are limitations to this even, such as always acknowledging the source is one of the limitations. One of the exceptions, which we frequently in the archives make use of, is that archives, libraries and museums can make copies for preservation purposes. So the preservation exception can only be used for material that is held in the permanent collection of an institution that is not available for loan to the public. For example, within the Shibden Hall collection, we have the diaries of Carolyn Wyville Walker. Unfortunately, these diaries are in a condition that means that physical access and handling in our search rooms would cause further deterioration of the record. And as such, we have made a microfilm copy of them, and they are now only accessible on microfilm to protect the originals. And copyright legislation in the UK allows for these kind of copies to be made to preserve the originals. One of the most important exceptions that we use and that people who visit us use is the non-commercial research and private study exception. So it enables us to provide a researcher with one copy for non-commercial research or private study. They can't make any additional copies of this material for other people. They can't WhatsApp someone a copy, email someone a copy, whack one in a shared drive, and they can't have also had a copy of that work before. You can only have one copy, and it does not permit publication of the item. Another really useful exception is for teaching and educational use. So this means that we can supply copies for handouts, for students doing examined essays, for use in a closed e-learning environment, for use in a PowerPoint slide, but not a set of slides that will then be had gone online on YouTube in a SlideShare, and not to publish online on an educational website that's open to everyone, as that would be publication, not supply of copies. So what does publication mean? So publication of a work in the context of copyright means the issue of copies to the public by sale or some other transfer of ownership, including making it available to the public by means of an electronic retrieval system. So the internet involves the use of an electronic retrieval system. So placing a work on a website publishes it, as well as communicates it to the public. And this sort of includes images of documents that we may want to put up on our online catalogue. Fortunately, providing access in our search rooms to the original works does not constitute issuing to the public, as you don't get to borrow the archives or keep them, you just get to look at them. There are provisions for the publication of sort of older works where the copy was supplied for research and private study, and the original is kept in a record office / public access facility. As long as it has not previously been published, it's at least 100 years old, its author has been dead for at least 50 years, and the current copyright owner is unknown to the publisher. The same for anonymous works. These may be published sort of without permission if it is reasonable to assume that the author has been dead for at least 70 years, which is sort of not applicable to Crown copyright works or works of known authors where the current rights holder is unknown. But these provisions are limited. We field hundreds of publication requests a year from our own audience engagement staff, and from researchers, from students, from academics, from historians, who all want to use quotes, transcripts, pictures of documents, and sort of other material in our collections, in talks, essays, books, exhibition posters, guides, journals, blogs, social media posts, a family tree hosted online, you name it, somebody's probably asked about it. And then any potential digitisation project that we may begin, where the end aim is to make material available to the public online, is a publication matter, and we need to consider the copyright status of everything involved, and clear the rights where we can. So dealing with every one of these, can I use a copy of this document for questions, starts with the answer, well, it depends. And then you'll immediately probably get sent a copy of our publication request form to fill in. So this is where you would record the document you are wishing to publish, the type of publication, which you then send back to us at the archive service. And at that point, we would check the copyright status of the item, let you know if any publication fees apply, and then we'd also look into depositor permission. Because the depositor or owners of the archival material, who probably don't actually own the copyright in the material they own, they too may have sort of moral rights over a decision to allow material they legally own to be included in a publication. So this is sometimes agreed in a loan or deposit agreement, where they upfront say the archive service can give blanket permission on my behalf. Other times I will need to go back to the depositor for permission, and we contact them out of courtesy as part of our depositor relationship management. So just because you've cleared copyright, there may still be sort of further permissions to gain and acknowledgements to be made. So this sort of particularly applies if the material is currently unpublished, as a permission of the owner of a document is also required for publication. And it can take a lot of time to get these permissions. So I would always advise making a request to publish as early as possible, especially if you have deadlines, as these things can take time. Sometimes we haven't spoken to a depositor in 20 years and we have old contact details for them, and it takes a bit of time to re-establish communication. So leaving things with plenty of time for any deadlines you might have is really important. So I'm going to look at an example of a publication request now to demonstrate sort of just how complicated they can get and give you some insight into the sort of thinking that goes into a publication request. So we hold a collection for John Crossley and Sons Carpet Manufacturers of Dean Clough Mills, Halifax. There are 961 boxes of archival material in this collection, which were deposited here in 1992. The collection contains records which include minutes, production records, employee records, and advertising and publicity records. Some of this promotional and publicity records include photographs from the 1960s of the showroom and of sort of behind the scenes workers. So far, so good. So if we received a request for a copy of one of the photographs from someone trying to publish a history of the business, what would we need to consider to sort of clear the rights? Are these 1960s photographs likely to still be in copyright? Almost certainly. So the next question would be, who is the photographer? Unknown. Were they an employee of the company? It's reasonable to assume that they are, given the types of photographs that they are. They're behind the scenes shots. So for the sake of simplicity, let's assume that the photographer was an employee of the company and that the rights are vested in the company as the employer. So who holds the rights? Well, the company dates all the way back to 1802, and the business was incredibly successful and it grew rapidly. By sort of 1953, John Crossley and Sons Limited and Carpet Trades Limited were amalgamated into John Crossley and Carpet Trade Holdings. And then in 1969, the company merged with another to become Carpets International. And then Carpets International was bought in 1985 by the John Crowther Group and renamed Crossley. It was then sold to Colourall Limited in 1988. Colourall then went into bankruptcy and Crossley closed in December 1990. And a liquidator was appointed in June 1990. And the company went into compulsory liquidation. Liquidators certainly have the right to view a business's intellectual property rights, including copyright, as an asset which can be sold. The physical mill buildings have since been acquired by Dean Clough Limited, a private family-owned business, but this does not mean they acquired the rights of the organisation based in the building before them. It could be that the copyright vests in the administrator of Colourall, and it would certainly be worth making inquiries with them. They could also be deemed as bona vacantia, which I'm terrible at saying, and passed to the Crown, which happens when a company is dissolved with all its debts discharged and the copyrights remain amongst those assets that haven't been sold. What we can say is that these photographs are orphan works. They're still in copyright, and there's a great deal more to be done to sort of satisfy the requirements of a diligent search for a rights holder. If we'd previously supplied a copy of one of the photographs to a researcher using the non-commercial research and private study exception, and they decide to publish, all we can do is warn them of the risks. The copyright declaration form that they will have signed to obtain the copy makes it clear that we have warned them of these risks and acted lawfully. However, if they hadn't already got a copy under the non-commercial research and private study exception, we cannot now supply a copy knowing that the recipient intends to publish, as there's no provision under the law that allows us to do that for records which were created this recently. And it would certainly sort of make us guilty of secondary infringement. So it's an altogether really unsatisfactory situation. Our hands are tied by the law, and we're not in a position to do anything further to help someone who simply wants to promote the history of Calderdale and of the business and our collections to a wider audience. So I think have some sympathy for any staff in a cultural heritage institution having to deal with or sort of copyright and we were never wanting to sort of block people from reusing content in our care. Probably quite a lot of time and thought have gone into tracking the history of the rights of a particular document across sometimes generations. And in the end, it's a very unsatisfactory outcome and people's hands are tied. So that's a shame. One thing that I think needs to be mentioned whenever doing any sort of talks about copyright or thinking about copyright is the digital age. It had a massive impact on all of our lives, including copyright, as the technology for producing copies has changed out of all recognition over the last 20 or so years, and the internet has changed how information is shared. Back in the day, the only copies that could be supplied were from black and white photocopiers or dubious prints from microfilm readers. And when we supplied copies of in-copyright works using the exception to, say, a family historian, they would probably take it home and pop it in a research file and nobody else would see it. Most publication requests way back in the day would have been for perhaps an academic journal with a relatively small circulation and a niche audience. If a risk was taken, the chances of a rights holder finding out were much lower. But these days, most people carry a high-resolution digital camera around in their pocket. Not only that, it's often in a device that has the ability to immediately publish that image with no context on multiple publishing platforms around the whole world instantly. So the risk of discovery of infringement has risen dramatically, and the technology makes it easier than ever to infringe. But so is the burden of proof to be able to look for a rights holder, where once you might have been able to say, well, I advertised in a national newspaper for a rights holder. Nobody saw it, nobody replied to it. I've done my work. The global reach of communications means that you can potentially find out about descendants across the world, so you probably should. And then the internet itself has created a whole new web of new interdependent formats, each attracting its own intellectual property rights. And the format of a material that satisfies the conditions for copyright doesn't matter under the law. A digital photo is still an artistic work, and an email or a blog is still a literary work. And a website itself will have numerous parts, all of which will have their own copyrights, from design, software, content. So within one website, there'll be a range of separate copyrights, separate copyright owners, separate durations. A blogger may own the copyright to the content of their blog, but they won't necessarily own the rights to the comments people make on a blog. And there are people all over the world aware and ready to enforce their rights, thanks to the internet. So the ability to share easily is one of the features of the internet that we all love, but it's one that the law doesn't really allow for. And the platform provided by the internet is very much the reason why archivists are constantly asked, why isn't it all online? Why can't we digitize it? The digitize of our creations, of our collections, is one of the ways people expect us to make use of our orphan works. There is an orphan works licensing scheme within the UK that allows for you to do this. It's quite complicated, it's long, it covers all sorts of things, and basically you get a license to be able to use records which last for sort of 7 years. You can use them for commercial, non-commercial, but there's lots and lots of sort of diligent research and information that needs to go into that. So the OWL scheme is a great idea because it gives you a legal way to do that, but some of the resources needed for an adequate diligent search can be enormous, and most cultural heritage institutions don't have those resources in staff time or in money to go sort of through that process, particularly in the case of more complex content. We're frequently asked if we plan to digitise and transcribe Anne's letters. And the diligent search is needed to clear the rights for over 1,000 letters with 250 different authors from different countries. Would be very resource heavy. So unfortunately, it's never quite as simple as just creating digital images of items and adding them online. And while there is this orphan works licensing scheme that may allow for that, it comes with its own issues, resources, expenses, and things like that. I'm conscious of time and that there might be some questions as well. So we'll just sort of end here with, this was a whistle stop tour. There is always more to learn about copyright and to know about copyright. It's complex. It doesn't really fit in with the opportunities that digital technologies provide. If you don't like the law, feel free to start a petition or contact your MP and ask that it can be changed. And if in doubt, always do your research, ask questions, and remember to leave plenty of time for dealing with copyright and permissions, as these things take time. I have popped our contact details on this slide. And now I will have a look at maybe some of the questions that have come through in the chat. I might be about to say it depends a lot, but let's have a look. Let me just see. Oh, so I think, let's have a look. Do all of the documents found in Shibden, along with the journals, fall under the same copyright since they were owned by the listers and then the property was gifted? No, unfortunately, it's never that easy when it comes to copyright. There are things in the Shibden Hall collection which will be the copyright of multiple different authors. I'm sure there'll be even some Crown copyright works in there that were created by, a member, someone working on behalf of the Crown, and there will be Crown copyright. There is no sort of one collection that has very rarely that has everything in this collection, same rights holders, same, rules. Every single document is different. Does it help you if the requester does the descendants research and brings you the resources when asking for that assessment? Does it speed up the process at all? when it comes to publication, if somebody's already done that work and has said, I've done all this work, I think this person is the rights holder, that is, of course, incredibly useful information to have, and potentially will speed up those initial conversations. So yeah, that's always a great thing to do your research, to know exactly, who potential descendants and rights holders might be. That can speed up the process a lot. Are archives exclusive to historians and authors, or also available to the public who wish to inspect them for historical research if they agree to copyright? So for us, for our collections here, we are open to the public and anyone can come in and see our collections. We don't have exclusive collections for exclusive groups or anything. The only thing we might not be able to show you a document for is if there's legal restrictions on access due to something like copyright. But for us, it's sort of entirely open to everything. So my chat's going. So look, can you publish a transcription of a document, or do you still have to think about copyright of the original work? Yes, you will have to think about copyright of the original work when publishing transcriptions, as it is technically a copy of a document. And if the original document is in copyright, then you will need to think about copyright. If the original document is out of copyright, you might still have to go through deposit permissions and things like that, but it wouldn't necessarily have to think about it in the same way as this document is in copyright. But yes, you would sort of need to think about that. So what is the definition of a known creator? Is it a sort of a celebrity, or is it a known creator is, do we know who wrote it? If it's a letter, have they signed their name, that kind of thing. It's, can you see who wrote this, who created this thing, is the idea of a known creator. If it's just a little document that's got absolutely no names or anything on it, then that would be an anonymous work because you cannot tell who wrote it at all. Oh, there seems like a lot of really good questions here, and I kind of wish I had way more time to answer these questions. Feel free to send me an email because I would, and I'm always happy to chat about copyright with people whenever they want. So if you have any of these questions, if I've not managed to get to any of your questions, because I know I certainly haven't managed to get to all of these questions, yeah, just send me an email. Always happy to answer your questions. And if I can't answer those questions, I can usually point you to a website that might have some good information or somebody that might be able to answer those questions for you. But I do feel like it's 4 now is at the end of the session, I believe. So thank you very much, yeah, for joining us, and I hope you found it at least interesting. Yeah, thank you very much. And yeah, I'll see everyone in a later session. I'm back again at 7 for the storytelling session.